Immigration attorney Sharifa Tharpe. I'm here live to take your U.S. immigration related questions. Put your questions in the comments now so that we can talk about those questions. I also want to address a very, very common question, and that's, can I get the work permit now? There's a lot going on in two states now. So in Texas, we have this law that's in place that criminalizes undocumented immigrants and possibly their relatives and friends. And now we also have that in Florida in some cases where, transporting undocumented individuals into the state can put you in jail. And so, with all of this urgency going on, the number one concern for many of my clients and many undocumented immigrants who are here is, can you get the work permit now? Now, this is why you always hear me push that you should schedule the appointment, because getting the work permit is, there's not a one size fits all solution here. Can you get the work permit now? Well, what I need to know is, who are you? What have you been through? What relatives do you have? When did you come into the country? What do you qualify for? Does a relative qualify to petition for you? Do you qualify for some other types of relief? This is where it's important to schedule an appointment to talk about those things. Today, I'm going to talk about the various ways that I've obtained the work permit for my undocumented clients. Now, the thing I want to warn you about is there are a lot of scams going on out there. Uh, First of all, do not seek the advice of a, somebody who is not an attorney or not an experienced attorney either, because even an attorney with very little experience in immigration can be harmful. You should get direct advice about how to proceed, preferably before you end up overstaying your time. Now, if you've already overstayed, there still may be options available, but it's going to depend on a number of factors. When I meet with individuals in the consultation, I ask them about 20 questions to get to the answer as to whether there's a way for them to apply for the work permit on right then and there. So it's just to show you how many different ways there are. Now, um, let us start with some of the more straightforward ways that I've assisted clients. So, everybody knows about getting married to a US citizen. Of course, it has to be a real marriage. So, you cannot be arranging to pay anybody to get you the green card. So, don't go doing that. Don't have anybody convince you to do that. It will open up a world of problems for you. It not only can create a world of problems for you in immigration, but it can also do it criminally, where you can be charged for doing something like this. And they're very good at spotting these things, and they're very sensitive to it. They're so sensitive that even bona fide couples have been caught up in that whole presumption that it's not a real marriage. So you want to make sure that you're in it for the love, right? Doesn't have to be a perfect union, doesn't have to mean that you're living a fairy tale, but you have, as a couple, you have to move, you have to be looking to the future together. You have to have that intention. You cannot have the intention of leaving that person after you get the green card. So, if you are a spouse of a citizen and you are, and right now I'm only talking about cases where you are undocumented. You're here, you overstayed your visa or your time, and you're trying to figure out how can you get to a point where you can be comfortable again and gain status. So if you have a permanent resident spouse, you're going to have to wait for them to become a citizen if you want to stay here in the U.S. and get your green card and get the work permit, because I'm talking about the different ways to get the work permit. Now, being the spouse of a U.S. citizen means that you have an additional perk here. That perk is, even if you've overstayed your visa and even if you've worked here without a permit, you can still get the green card through adjustment of status. They don't use it against you to deny you. They will not deny you because you overstayed your time. There are a few exceptions to this rule. And for example, if you came in on a crewman's visa, then you will not qualify for adjustment of status. Crewman's is where you work for an airline, you work for a ship, and they gave you that special visa to stop off in the U.S. Until you move on to another port on the ship or the plane. If you entered with a crewman's visa, you'll not qualify for adjustment of status. So be very careful about overstaying that visa. Another one is if you have the J1 and you have the 2-year foreign residency requirement, you'll have to go through a waiver process to be able to get that 2-year foreign residency requirement waived. The 2-year foreign residency requirement is for certain, not all, but certain J1 visa holders that basically says when they're finished with their program, they go back to their country. They have to stay outside of the country for 2 years before they can move on to any other kind of status. There is a way to get that forgiven. So for example, if your relative is going to face exceptional hardship, so that's a very high bar to meet, exceptional hardship, so extremely unusual, extremely unusual and exceptional hardships, then you may be approved for the waiver of the 2-year foreign residency requirement. So for example, if you're married to a spouse here, maybe you had a child already, and your child cannot leave the country, will need you to be present to continue getting maybe medical care or therapy if they have a disability. That's an example. It doesn't mean that if you don't have this situation, you can't qualify, but that's an example of the type of situation that could get you the exceptional hardship waiver. The other is a no objection letter. So, I don't want to go off on a different topic here, but I just want to let you know about those two exceptions. So, being the spouse of a citizen, if you don't have a crewman's visa, you don't have the J1 visa that has a 2-year foreign residency requirement, then it's very likely that you're gonna be okay in the adjustment of status process. Now, the great thing about the adjustment of status process is that you are going to get your work permit while the process is pending. Right now, they're giving away 5-year work permits. So 5-year work permits. That is because some of the processes are so backlogged that they have decided to give the 5 years. So no matter how long your process takes, you don't have to go through the stress of seeing your work permit expired or having to reapply for it every year, because here's how it used to be. So it's every 2 years. Now it's 5 years, but before the 5 years, it was 2 years. 2 years goes by very quickly. We have to apply to renew around, the 6-month mark before it expires. Then it takes another 6 months for them to even send you something, sometimes longer, to send you the new green card. And then by the time you blink, it's time to renew it again. So it's very stressful, because when employers are involved, now they're threatening to terminate the client's job because they're not getting the work permit. Now it's 5 years, so we're not going to be seeing that so much. And if you have to renew yours, you will get the 5-year work permit. So that's great. Now let's talk, and then you will wait until you go through your green card process, the marriage-based green card process adjustment of status is roughly, so my shortest case has been 4 months, but I say prepare for 8 to 12 months. My average is 8 months, but it could be more just depending on the complexity of your case and if there are additional factors in your matter. Now, this rule does apply. This rule where you can get the work permit and apply for adjustment of status with certain family members does apply to children of citizens. Now, don't make this mistake. Children of U.S. citizens who are under 21 can apply. So if your child is 18 or over the age of 18, they will still be in this preferential category where they can go through the green card process while being here, even if they overstay their visa and even if they've been here working without a permit. Please don't make the mistake of assuming that if your child is now 18, you can't apply, sponsor them, or if you're the person here that since you've reached over the age of 18, you can't qualify for this. You can, as long as you're under 21. So you can get the 5-year work permit through your parent, your U.S. citizen parent. Now, just want to say here, if you are 21 or over, that will not apply to you, because I get a lot of questions about that. I want to make it very clear. That will not apply for you. For these individuals who call me and they're already 21 or over, I look to other solutions for them because it's not going to lead to a work permit, and it's going to lead to a 5 to 7 year process of waiting in the US without status, being in the same situation. So if you're over 21, we need to 21 or over, we need to figure out something else. And as usual, the consultation is going to be where that can be done. So now the last preferential category is if you are the parent of a U.S. citizen who is age 21 or older. If that child is 21 or over, then you can go for the green card through your child, get the work permit while you wait for your process. And this is a 5-year work permit. Through this family-based process of adjustment of status, you will be able to get the work permit in on average, I'm seeing 3 to 6 months to get the work permit. Now, it's not to say I'm focusing only on undocumented immigrants. That means that you've already overstayed your time and you can't show that you are still here on legal status. So it's not to say if you are the spouse of a permanent resident, you may still be able to apply for adjustment of status, but you have to be in status, meaning you did not overstay. Your priority date has to be current. Right now, we're on the date of, the last I checked, we're on the date of September 1st, 2023. That's the priority date. That's like the wait list, right? So that's the date that's at the top of the wait list. What that means is anybody who filed their I-130 an I-130 is a petition your citizen or resident relative submitted for you. If the priority date is on or before September 1st, 2023, then it means you can still, and this is for anybody, by the way, this is for spouses of residents. If your application is before that date and you're currently here and you are in status, then it means that you could possibly qualify for adjustment of status. So don't count yourself out. This is where it's so important to make sure you schedule an appointment before you do anything, before you make any big actions to figure out what to do. Because one big thing is I see so many people make assumptions about what they do qualify for, what they don't qualify for, and it leads to a lot of regrets in the future. Or they find out they could have applied for something, but now it's too late. Now that was how you can obtain the work permit, even if you're undocumented, meaning even after an overstay here in the U.S. with your spouse, your parent, or your adult child who's 21 or over. Now, what if you've been here and that relative, you have no hope of that relative even applying for you, because with the family base, they have to petition for you. But you have no hope of them petitioning. You don't have any hope about them petitioning for you because they've maybe said it or they've shown you in so many actions that they are not going to do it for you. Um, First of all, I do see that as a red flag for mistreatment, and that's where I dig deeper because usually there's a control factor there. They have you where they want you. You're undocumented, so they can control your movements. They can tell you that they can tell you where to go or what to do, because if you don't do these things, you're gonna be deported. And so it opens up the door for me to explore whether you do qualify for VAWA green card based on that mistreatment. Now, the benefit of the VAWA green card is while you get to control your own process, you apply for your own green card, you apply for your own VAWA status, you apply for your own work permit, and you don't have to show that you are making a certain amount of income to qualify for this, right? So you don't have to present your income or present the income of anybody else to show you qualify here. Now, what the benefit also is that you are able to get your work permit and your travel document while you wait for the entire green card process to be completed. So, what has to be present here is you're experiencing mistreatment. So, this includes verbal abuse, mental abuse, emotional abuse, financial abuse, or extreme cruelty. For example, under immigration law, extreme cruelty could be constantly telling you that if you don't do something, they're going to get you deported or they won't file for your papers. That's considered extreme cruelty because they're using your immigration status against you. Physical mistreatment, police report, medical report showing injuries, pictures are not required for this. So, what I want you to think about is, are you experiencing this situation? If you are, give me a call and we can talk. Because if you're experiencing this, then it's very likely that you qualify here. So we look at that, and then we also look at your history with the spouse. Did you live with your spouse? Did you live with the parent that mistreated you, or did you live with the adult child that mistreated you? So that's also a requirement in this process. And then showing that the relationship is there, the marriage, showing a bona fide marriage, or showing that yes, you do. For example, if it's a step parent, step child situation, that that relationship is truly there. So what happens here is that we go ahead, we file the petition, and this is extremely confidential. It's not going to be disclosed to that relative that's mistreating you that you're applying for this. It's actually against the law for immigration to contact anybody and disclose this information, contact anybody outside of the agency. Now, we submit the petitions, the work permit, the adjustment of status application that's going to get the green card, and the travel document. The travel document and the work permit are also 5-year work permits, and the travel document is 5 years, the work permit is 5 years, and what that means is that you will be able to because this process is 3 years from beginning to about green card. So once again, they want to make sure that you're comfortable, you get your social security number, work permit, travel document while you wait. This can be expected anywhere from 6 months to a year from the date of filing. So that is VAWA. Now, let me just repeat who qualifies under VAWA. So if you are married to a citizen or resident, if you have a parent who mistreated you and you're under 21, or you're under 25, and we can show we can show a valid reason for the delay of the application, or you are the parent of a citizen. You are the parent of a citizen, yes, who's age 21 or older, who mistreated you. If this person mistreated you when they were 18, 17, maybe, for example, you were mistreated because maybe they were on drugs at the time, maybe they had problems, and they lashed out at you, you could still qualify for this when they turn 21. So that is under VAWA. Now, if I have a case or situation where the person I'm consulting with, they have no relatives here, they have no, and so that means no VAWA, no relative petitioning for you, I look at what are alternatives for them. And oftentimes, when an individual is here without family, they're by themselves or they have to be depending on distant relatives and friends, it means they've been through a lot. And in that case, it also means that, unfortunately, there's a lot of trafficking and exploitation and abuse of undocumented immigrants here in the US. So people have the misconception that undocumented immigrants are living off of the system and they're bad people, they're illegal. But the truth is that a lot of them are being exploited by citizens and residents here, by people who are here legally, that would turn around and tell them that they're undocumented. Those are the same people that are exploiting them, abusing undocumented immigrants. So life is not easy here, being without status. It can be very difficult. And so the one of the things I do is I delve into the background of the person that I'm talking to find out what kinds of situations have they been in, and does it qualify them for relief as the victim of labor trafficking or sex trafficking. And you would be surprised how many people qualify for this. It's unfortunate, but it is a real issue. And I think one of the things is people are not very educated about trafficking, not even the people that talk to me. They themselves are not educated about trafficking, and so I have to evaluate the aspects of what happened to them to determine whether this is as severe as trafficking. And I think that's one of the reasons why so many people continue to be victimized this way, is because, on a whole, it's not, when we think about trafficking, people think about somebody being kidnapped and locked away, and they only think about it in the context of sex trafficking. They don't think about the different ways that an employer or a relative or an intimate partner can maintain, control, and manipulate an undocumented immigrant just through emotional coercion, or verbal abuse and mistreatment or deprivation of their wages. It is a very common thing. So oftentimes, when I do these detailed evaluations, I am able to find that my clients do qualify for the T status as victims of trafficking. And many times, my clients were here because of the trafficking. They were recruited here with the promise of work permit, with the promise of getting their green card. So they came here having full faith that the individual would get them their papers, and it was all a fraud. That is trafficking, by the way. So trafficking is where they get you to work, they get you to do things for them under fraud, coercion, or force. So force could be the physical force. Coercion is where Maybe they don't pay you, they overwork you, underpay you, skip out on your payments, tell you they're not going to pay you because you're undocumented, start using your status against you, and this could be indirect too. It doesn't have to be where they outright tell you, but through their actions, through the patterns of their behavior, they are stopping you from leaving the situation because maybe they're not paying you. You have very little money to escape the situation, so you keep going and you keep going, hoping that they will pay you. Sometimes they make your wages so low that you can't escape the situation, right? You can't possibly leave because maybe you have nowhere else to go. So this is where I say, let's talk about your situation and figure out if the T status works for you. Also, there's if you're the victim of certain qualifying crimes. So the qualifying crime is determined by whether you experienced mental or physical abuse in the course of the crime. If you did, then it could very well be a qualifying crime to be able to get deferred action and eventually the U visa. The U visa is not as good as the T. Oh, by the way that the T visa status works is that you are able to get your 4-year work permit upon approval, and then you also have the option of getting your green card after you've been approved for the T status. Now, with this does take about a year for the decision to be made, and for you to be able to gain status here under T status. Now, with the U as a victim of a crime, it is the less preferred. If it is your only option, by all means pursue it. But with this one, it is up to 10 years to get it. You can get deferred action, and it takes about 2.5 years to get deferred action, meaning with the deferred action, you're able to get your work permit eventually through that. So now the last is asylum. Even if you came with your visa, you can apply for asylum. Uh, you're usually given the option when you're coming through the border. They do ask you, they do a credible fear interview sometimes to determine whether you qualify, or they refer you to the immigration court. If they haven't referred you to immigration court, it's not too late to apply for asylum. With asylum, do you have a fear of going back to your country? If you have a fear of going back to your country because you're being targeted in some way, let's talk and figure out if that could be a solution for you. After 150 days, 150 days after applying, you can apply for the work permit, and the work permit is a 5-year work permit. So because the asylum process can be 3 to 5 years long, many people are still waiting for their interviews for a determination about the asylum. So all right, so I'm going to quickly answer some questions. I'm going to go really quickly because I do have to leave in 3 minutes. So let me go ahead and just scroll through and answer some questions. So in a nutshell and summary, those are some of the ways that I look for status and the work permit for my clients, for them to get the work permit. There are other things like deferred action that may be available if you're facing unusual circumstances. TPS, if you're a part of a country that has been designated a TPS country, for example, Haiti, Venezuela, Ukraine have been some of those countries. With an ITIN paying taxes, can you get a work permit? No, so that's false. So I got a work permit approved yesterday. Good. Congratulations. No card being produced or case approved, but it was under documents tab. How long after? So the work permit, you can expect it in about 2 weeks. Can you help someone that had been approved for their documents for 13 years but haven't yet to receive work permit, travel document? That's a long time to wait for the work permit. Definitely get legal advice if you've been approved for something but you never got it. When should one start counting VAWA case? Is it when you get the receipt notice or when you get the prima facie? So the receipt notice has the priority date, so you'd count from there. I can't leave my spouse, and I can't live with my spouse anymore because of how he is, but we do go out just the same. So give me a call. Let's talk about your situation and determine whether VAWA could be for you. How long does it take to get a minor travel authorization? She has been confirmed a case of an 134A program. So it differs. I'm not sure after approval how long it will take to get the travel authorization for those. And this is the special parole program that's going on for certain countries like Haiti and Venezuela. What's doing a J1 visa waiver, will sponsor be notified? When doing a J1 waiver, will the sponsor be notified? So no, not necessarily. It's going to be who is applying for it that's going to be notified. You're the applicant, so you're going to be notified, not the sponsor. Thank you for always being here to give great information. Thanks so much, Def Hey. I appreciate that, and I'll keep showing up. If you have overstayed B1, B2 visa, are you eligible for the 5-year work permit? If you overstayed, it depends. So most of my clients that I've gotten the work permit for have overstayed. I'm not telling anybody to overstay because it's the tough way to go with this. But you do, if what I would say is you may qualify for the work permit despite the overstay if you have a relative that can petition for you, if you face circumstances where you can get relief. But just by overstaying, that's not going to get you the work permit, because remember, overstaying is an immigration violation. So I'm not saying that overstaying gets you the work permit. I'm saying that I aim to assist individuals who are here because for one reason or the other, they ended up overstaying and they need assistance. There may be ways, and that's just all dependent on the individual. Can I make a lawyer file my I-130 for a petition in Jamaica, married to a citizen? Let's talk. So there are different rules that apply if you're the spouse of a citizen and you're outside of the US. So we'd need to talk about that. You'd either have to face some of the mistreatment in the US, or your spouse would have had to be in the military or work for the federal government to be face the abuse outside of the US and qualify. So let's talk and we can see if you could qualify. All right. The process, thanks so much. The process is 12 months, 12 to 18 months. How long after interview can you get the green card? So I've seen the approval in a day, usually, and the green card come in like a week after the approval. Can you help someone get a work permit if your family promised to help you but kick you out and not help you at all? So those are facts that are too little, but that's usually a red flag for me to delve deeper to figure out what happened. They promise to help you. Usually when I hear they promise to help you, they usually say, can you come and take care of my kids and I'll get your work permit? Or can you come and help me work in my business? I'll get you your work permit. I'll get you your green card. I need you to come. And then when you come, it's a whole different story. You're not being paid. You're overworked. There's no telling you have no choice and you're undocumented and they can do whatever they want. That can qualify you for T status. So this is where it's important to have that conversation. Keep in mind that the consultations are confidential, which means that you will not have to fear. Nobody's getting in trouble for telling me straight up what happened to you. It's confidential, and sometimes it's why I don't offer therapy services. The goal is not to offer therapy in my consultations. It can be a relief for individuals to be able to finally tell me what happened to them. My I-130 got approved. How long would it take for the I-485? So it could take a few weeks to months, just depending on what else is left. All right, so I'm going to answer a few more and then I have to head out. I just sent my RFE medical for marriage-based green card. How long will it take to get the green card? So it could take a few weeks to months. How long to get the receipt notice? No, for VAWA, file concurrently. So it could take anywhere from 2 weeks to 2 months, just depending on how backed up they are. Why do companies don't pay unemployment? So I'm not an employment attorney. I wouldn't be able to answer that. Um, how long to get a receipt notice? No. Okay, so I answered that. Do they do interview for kids and 600? And can you please explain the process? So they may not, so if it's the case is straightforward, they may not do the interview, but if they do have questions, they may schedule the interview. Now, there are different types of N600s and different scenarios. So, for example, there's a situation where if the kids have gotten citizenship, but they have lived their whole life outside of the US and now they came into the country with a visa and now they're looking to get the citizenship. There is an interview process. But for the plain N600, where they're already a citizen, they just want the certificate. Unless they have questions, they don't usually schedule the interview. Can I use screenshot messages for bona fides? Yes. I would say, you know, they're very open to all sorts of evidence, but it has to really show that it's bona fide. Lovey-dovey messages with nothing else in the application is not going to be very convincing. All right, that's going to be it for me. Thanks so much for your time. I will be back hopefully tomorrow where we can answer more of your questions. All right, thanks everyone. Bye bye.